Hello and welcome. I'm Yamini with Paul Vorbach from AcademyGlobal. Today, we're talking about alternative dispute resolution, or ADR, in public sector contracts. It's how governments resolve disputes without ending up in court. And it matters most than most people realize. We'll cover what it is, the main methods, and how to choose between them. What actually is alternative dispute resolution, and why does it matter so much to public contracts compared to going to court?
Thanks, Yamini. So alternative dispute resolution recognises that rarely is the best outcome for two parties in a dispute to go to court and endure a legal process. Now, there's several reasons why going to court and going through an extensive legal process is problematic. The first is that it's expensive. It's time consuming. Not only is it time consuming in terms of the preparation, but court decisions can take, in some cases, a long time, sometimes years, in order to be made and judgments to be arrived at. So there is uncertainty in matters that are taken to court, and there's also risk associated with not being able to influence the decision-making process. So a court process is one where both parties, either intentionally or just through their actions, defer power to a court, a magistrate or a judge, agree to pay a lot of money, have little control with uncertain time frame. So when we put it in that way, the court process should sound pretty unattractive. And yet, so often people go to court unnecessarily. Now, in the public sector environment, going to court is also, by definition, a public process. So the opportunity for things to be discussed in court, for decisions to be made in court, which might reflect very unfavourably or or both parties, is always a risk as well. So there are a number of reasons why court processes are unattractive. Now, the reason why the court process is always an option stems from the fact that agreements called contracts, and not all agreements are contracts, but those agreements which are formed as legally enforceable contracts have a very particular right to award damages to a party who has been injured or suffered a loss as a result of the other party who could have kept to their end of the bargain, not keeping to their end of the bargain. So the basis for the right to go to court stems from the legal rights which are available under contracts, and breaching contracts brings with them this basic, what we call common law right to recover damages or sue for damages. So that's one of the reasons why anything that will save us from that process is generally seen as being attractive. The limitation of alternative dispute resolution, or ADR, processes is that they don't bring that big stick to bear. So they don't bring the authority of a court to be able effectively, if you like, to punish the party who was not innocent and therefore award damages. So there's pros and cons of both parts. But increasingly, and it's been the case for some time now, most senior executives across public sector think it's best to try to solve problems before the need to go to court. So the alternative dispute resolutions are mechanisms that are agreed to through the contract, which stipulate that if we are in conflict or disagreement and there is a dispute, that we will follow a series of escalation points before we agree to go to court. So that's the basic explanation as to what ADRs are and how they differ from a court litigation process.
Right. And so if court is the nightmare scenario, what are the alternatives?
So most of the dispute resolution clauses within our public sector contracts include a stepped process starting with negotiation. Now, usually, but not always, the dispute is first felt and involving those who are managing the contract from the contractor or supplier or vendor's side, so the private sector typically representative, along with the person who's sitting in the department or agency who's been designated as the contract manager, or if it's a construction contract, we might call them a project manager. So usually the dispute starts between those two parties. Now, the expectation under the contract is that we can negotiate as people who are familiar with the dispute, directly involved in the dispute, and we'll be able to work our way through as adults who are sensible, who can see it's in our interest and it's in our organization's respective interests to solve this. So there's a lot of expectations that we can address this at the front line effectively. But commonly what happens through disputes is that it becomes personal between the parties. People may have felt that they were lied to, or that something was misunderstood, or someone's trying to take advantage of them. Now, that might be the case, but it could in fact be fictional. But as long as that perception exists in the minds of the parties, then the likelihood of them being able to cooperate starts to diminish. So the negotiation expectations under the dispute resolution clause means that if Paul and Yamini were in a dispute, we would both refer this matter up to our line managers or someone of a higher authority within our respective organizations. So you may escalate this to your manager. Paul may need to escalate this to his manager. And then a similar set of assumptions apply that hopefully we have executives now or senior managers within the organizations who can see what's clearly in the organization's interest to resolve this as adults behaving professionally and working through what they can work through before they need to follow a subsequent step. Now, if your manager and my manager are equally unable to resolve this, then the process that is followed requires a mediator to be appointed. So both of our organizations need to fund the mediator under most arrangements. Usually the costs are agreed 50-50, and both of us will agree on the choice of who the mediator is. Now, the mediator is an independent third person. They may have legal training, but they need not have legal training. And their principal role as mediator is really to help both parties understand why it's in their own individual interests, why this should be resolved. So they really try to work on the communication process between the parties. They try to help each party see it from the other party's point of view. It's almost a bit like a counsellor type of arrangement in terms of how a mediation process works. It has no legal authority. A mediator cannot bind anybody to a decision, but highly skilled mediators can be incredibly effective in taking the sting and the pressure, the pain, and the heat out of a dispute and creating the space for both parties to be able to come together and start to collaborate effectively. Now, in the event that the mediation process doesn't work, we may then go to a process called conciliation. And a conciliation process differs from a mediation in a couple of key ways. The first is they are also independent. They have no power of decision to force either party to do anything. They are interested in trying to drive the behaviours in a direction which is going to be constructive for both parties. But they introduce typically some level of knowledge and awareness of subject matter expertise. So as we start to get towards an environment which might require some litigation and legal decision, they're starting to alert both parties to what this journey might look like if we cannot resolve this between us. So they might start to give some indication in terms of what the financial burdens might be, the time obligations. They might share some insights in terms of similar matters that they're aware of that have been through a court process, for example. Again, really attempting for both parties to decide it's in their own interest to get this conflict addressed and to resolve the dispute between them. Now, the next part of the process, and it's important, Yamini, that our viewers understand this is not always prescribed within the contract, is what we call an expert determination clause. Now, the expert determination clause most commonly appears, if it appears at all, in construction contracts. And the expert determination clause is where both parties agree when they sign the contract that if they have a dispute, that they will seek the decision of an expert determination expert. And that person they provide authority to make a decision. Now, that decision may or may not be acknowledged and recognised by a court if it goes to court. Now, there is another process which may be followed, which is called arbitration. And arbitration decisions can either be legally enforcing by courts, or they may be left to the goodwill of both parties to agree with the decision of the arbitrators. So there's a bit of difference depending upon the nature of the arbitration court, the jurisdiction in which it operates within as well. Arbitration processes look and feel quite legalistic. There's representation to the parties. The physical environments sometimes are set up to look like court-like environments. And as I say, in some instances, decisions made by arbitration courts will be recognised by courts even in different jurisdictions. So international courts of arbitration, for example, in Singapore, which are recognised across various Australian states, and vice versa as well. So these can be cross-jurisdictional and can be very, very interesting and useful ways to resolve disputes without that narrow court process, which is the one that we generally want to try to avoid as much as possible, certainly from the public perspective, and commonly, but not always, from a major private sector perspective as well. There's two lenses to look through in terms of addressing whether we've got a better outcome through an alternative dispute resolution process than litigation. The first of those is to say, has the matter been addressed in a way which is timely, provides confidence to the public, and represents value for money? So if at the end of a legal proceeding, it's cost us a lot of money, it's undermined the public's confidence, and it's taken us forever to resolve this issue, you can probably say without scratching the surface beyond that, that it hasn't been a successful course of action. And really the hierarchy on dispute resolutions that I described, negotiation, escalation, mediation, conciliation, expert determination, or arbitration, all of those steps are really designed to reflect that incremental risk and incremental cost of time and money in each subsequent step. So that's really the lens to look through. The other additional consideration that the public sector's got to be very aware of as well is that because decisions made by courts are public, overly aggressive litigation by the public sector can sometimes send a bit of a chilling effect to other parties. So some parties might say, well, look, if we are less experienced, less commercially astute, and we find ourselves in a dispute with a government agency, we might be taken to court, we may be sued, that may cost us so much money, it may ruin us financially. So the risk of entering into a contract with another party who's seen as being overly litigious is a risk that's got to be considered commercially. And when public sector organisations, as a result of changes in government policy, are seeking to include more smaller businesses, businesses increasingly which are owned by Indigenous and Aboriginal peoples, businesses that may employ people with disabilities through not-for-profit organisations and charities, signalling a very tough commercial stance is something that I think most governments are cautious of doing.
For teams wanting to build that capability, where should they start?
Because the most obvious evidence of ineffective dispute resolution manifests through one of the processes that we've described, particularly the higher level processes. And I'm thinking about conciliation, arbitration, expert determination, and of course, worse again, litigation. There are markers which are available for contract owners, for senior executives in public sector agencies to identify patterns and what types of contracts are more prone to dispute. And when disputes arise, who are the individuals? What's the nature of the underlying work? What's the nature of both parties that more frequently gives rise to disputes that are unable to be resolved through negotiation and or mediation? So I think that's the first point of awareness. The second is that looking at how projects may be delayed or budgets may be blown out because of disputes is another objectively verifiable marker that we've got a problem in our dispute resolution process. So once the recognition is there, the next stage then is to think about what are some of the capability related interventions. And AcademyGlobal has a range of different contract negotiation, contract law, programs, dispute resolution programs, and negotiation programs that are focused very, very clearly on the commercial contracting environment and provides both a solid legal basis to each of the different types of dispute resolution methodologies, but most importantly, I think also shows the practical way forward. So how these ADR techniques can be used to try to achieve a broader value for money outcome within the spirit of demonstrated probity as well.
So that really is a clear guide to keeping disputes out of the courtroom. So thank you so much, Paul, for giving us such a detailed explanation for the methods, and thank you all for watching.